afternoon, everyone. My name is Kevin Cosgrove. I'm a patent attorney with Alkermes Pharmaceuticals based in Athlone. I'll begin this talk just with the quick caveat that the views expressed here are my own and not necessarily those of Alkermes. One thing I just wanted to say at the outset is the talk assumes a certain understanding of patents, so apologies to those who may be complete beginners, but hopefully there's something in it for everybody. I've tried to put together as many slides as many different aspects of this topic, but I won't be able to talk in detail to all of them today. So if there's anything that I put up that piques your interest, of course, please feel free to come and talk to me after the talk. So, first of all, the role of any IP department in a company is to ensure that the IP strategy is aligned with the business strategy. And in doing this, there are a number of general issues which you need to consider. First of all, what is it that you're trying to sell? What activities, what products, what services do you need to protect? Do you have an IP budget in place? Because obviously these activities need to be funded. Patents are quite expensive to obtain and to maintain. And the larger the budget, the more extensive the protection you'll be able to obtain, the more territories you'll be able to cover, for example. Do you have appropriate procedures to manage your IP? So do you have a way to make sure that patents get filed on time? Do you have procedures for, if this is especially relevant with larger companies, if you have a lot of patents, a large portfolio, do you have a means for actually reviewing that portfolio over time and making sure that the less relevant patents, because the business strategy might be changing all the time, so do the patents actually support the products you're trying to sell? If they don't, they become a dead weight because you're paying maintenance fees on them all the time. So just a means to actually cut out what's not useful or not supporting revenue. And also, does the project team understand the IP strategy? If there are IP deliverables, especially from R&D functions, people need to understand what you're trying to do from an IP perspective, what you're trying to actually protect, and if they need to generate data sets that they're made aware early on in the process, and they can do that. Clarity in roles and responsibilities is always important. Integration, this is a really important point. If your patent attorney understands the science of what you're trying to do, they'll be in a much stronger position to draft the patents in a way that they take account of that science and that they're much stronger. Coordination between functions on patents is very important. For example, in the life science industry where I work, if you're making regulatory submissions on a new product, you want to make sure that you're not making statements in the regulatory submission that contradict what you might have said in a patent. Or if in promotional materials, for example, you want to make sure that everybody's on message and everybody's working together. So I put up this slide. I'm not going to talk much about it, but the point I was trying to make here, I picked out some cases which are of relevance to this topic. And most of these cases concern changes to the law in the various jurisdictions on what's considered to be patent eligible subject matter. And this changes all the time, and the point I was trying to make here is that when you're drafting patents, you need to take into account that the law changes as to what you can patent and what you can't, and you need to try and cover or protect your invention or describe it in as many different ways as possible. One thing I want to highlight as well from this slide is that in the US, in the last 5-6 years, there's been a pretty momentous change by the introduction of the America Invents Act, and that has changed the way patents are done in the US. One of the things that this Act introduced was a mechanism for challenging granted patents, and it's proving to be very, very effective at overturning and invalidating patents. So when you're drafting your patent, you need to take into account that it is becoming easier to challenge them, and you need to put a lot of effort into making sure that your patents remain valid and stand up to challenge. So how do you do this? Well, to go back to the basics of what a patent is, it's basically a deal between the inventor who discloses fully their invention and instead of keeping it secret. And the benefit for the inventor is that they get a 20-year monopoly from the state. Now, in order for this to be useful for the inventor, you want to make sure that that monopoly covers, the scope of that monopoly covers your preferred product or what's likely to be your marketed product. And the best way to do that is to actually describe that marketed product in your patent application. And in order to do that, you need to make sure that you identify all the possible marketed products at the stage when you're drafting the application. This is just a summary of some of the main requirements for patentability. I'm going to talk about these a little bit more in the next few slides, but One key point I want you to bear in mind is that when you file a patent application on a particular date, you cannot come along and add new material to that patent application after it's been filed. That's a really crucial point. Now, some of the more patent savvy among you might know that there is a procedure under the Paris Convention that you can file one application today and a year later file another new application that claims the benefit of the first one, right? But the thing is that if you add new subject matter to that new patent that you're filing, it doesn't get the benefit of that first filing date, and in some situations that can be really crucial. So the one thing, if you take away nothing else from this talk, is when you're filing your application, you need to try and think about as many things as possible and get that at least factored into consideration. So, when you're drafting your patent, there are a couple of tips that I can give you today. One of the really important things from the outset is to make sure that you understand what the invention is and how it works. And the best way to do that is to have your R&D team work with your IP team, or whoever is drafting the patent if you have an outside counsel attorney doing it, so that they're working together to see all the different ways that the invention can be applied. Because often when the invention is difficult to identify sometimes, and once you understand what it is and how it's working, you can start to think about all the different ways you can vary that invention and it still works to achieve the same effect. An interesting example that I've cited here is Medinol. It was a case that appeared for the Irish courts a couple of years ago, and it was around the idea of a stent that when you put it in situ and expanded it, there was very little shrinkage outwards in a lateral direction. And this effect was really attributed to the fact that the design of the stent was that these bars in the stent were in phase with each other, so that it was quite clever the way that it was expanded, but it didn't shrink. The problem is that the patent application described this effect, but it only described the effect working when the bars were in phase, not when the bars were out of phase. I'm not sure if it's easy to see, but the point I'm trying to make here is that if you describe your invention as working in a particular way, you can't come back later and try to claim other ways in which you haven't shown it to work. And that's why understanding how it works is important from the outset. Another tip when you're putting together your patent application is if you're relying on a feature that you're going to use to say, this is what distinguishes my invention over everything that went before, that feature is going to be very important to the validity of that patent. And you need to make sure that you understand that feature and describe it well. If the feature, for example, is a measurable parameter, so let's say what's in the prior art was something that you measured and the measurement is different, you need to make sure that you describe all the ways that you can actually measure that in the patent, and also that you account for any variability in the way that it's measured. It was a case that came before the US Supreme Court quite recently, and it concerned a device that's used on an exercise bike. The idea is you grip this bar and you put your hand over these two terminals and it's able to measure your heart rate based on that. Now, the invention and the way it was described, because it was a concept that was kind of known before, this was a patent that was published before the other one, and in this one, it's not really easy to see, but these two terminals were right beside each other, whereas the invention here was that you spaced the two terminals out and it gave you a better reading. It seems like a small thing, but it was quite significant in terms of the effect it had. Now, the problem was that the patentee went and claimed it, and they talked about language of a spaced relationship of these two terminals, but they didn't talk about in the patent what the spaces could be. They didn't describe examples of what the spaces might be. And that created a real problem down the line, because if you look at that, legally speaking, a spaced relationship could mean a really broad space, or it could mean a tiny space, in which case you're more similar to this, where the two bars are right beside each other. So that really highlights the point of just understanding what is the point of your invention, and how to actually make sure you characterize it right. Claiming the invention, another thing that's very important. As I've said, you need to have R&D and IP team working together to make sure that you look at all the different ways that the invention could be commercialized. You also need to think, when you're drafting a patent application, you need to think from the perspective of a third party, another company, looking at your patent claim and saying, how do I avoid infringing this patent claim? What ways can I design my product so that it takes the benefit of this patent, but it's just slightly different and gets around the claims? the R&D team is really in the best position because they understand the technology well, so that they can think of all these slight variations and modifications. So that's another important point. Another point that I wanted to make here is that it's more to do with life sciences, but if you're relying on a particular data set to support a claim, you need to make sure that the data actually supports the full extent of what you're trying to claim. If you're trying to claim a lot of different drug compounds, let's say working for a particular effect, you might need to generate further data sets to show that it works with different compounds and not just one class, let's say. I've put together a quick slide here just on the idea that large organizations in particular, but all organizations, need to have some system in place for vetting disclosures within their company. Because if you disclose an inventive concept before you try to obtain patent protection, that can be fatal. Because it becomes part of the prior art and you might not be able to get a patent at all. So there needs to be some mechanism in place by which when people are going to publish things or talk about things in public, it's vetted first. And I've put together a slide here as well, just talking about the benefits of having a system, an invention disclosure system in place in your company. So if there are R&D teams generating new ideas, there's a way of making sure that these are captured, put into an invention disclosure form, and they're considered. Each new idea is considered and a decision is taken as to how to proceed. Because it seems like something simple, but if you don't have it in place, there's a possibility that people could come up with great ideas and that they never get captured and nothing ever gets done, so they fall through the cracks. The last slide, I just wanted to make the point here that right throughout the development cycle of a product, it's often the case that there are refinements being made to the product all along. So you file your patent application, but then the product changes quite a bit as it's developing. All those changes need to be fed back to your IP department so that you can actually take account of the changes and tailor your IP strategy appropriately, because there's a lot of different activities that happen right up to the point of the product launch. So I've just put together a few summarising points. As I've said, if there's anything of particular interest here, feel free to talk to me. I hope you've taken something useful out of it, and thanks very much for listening today. Thank you.
Any questions for Kevin?